My name is Robert Offcaesar, and this video is focused on a few key components of a pour-over will. What is a pour-over will? A pour-over will is a type of will designed to pass an estate through a trust, usually a revocable living trust. The dispositive terms of the estate plan are found in the trust, not the will. In other words, you won't be able to tell who the ultimate beneficiaries are just by reading this will. You'll also need to review the trust agreement. So what's the purpose? The purpose of this type of a will is to provide a mechanism for passing probate property into and through a trust. There are many reasons for wanting to do this. Privacy is one. A will is a public document and anyone can view it. Trusts are more private. Also, control. You might want to create a more elaborate structure for how estate assets are managed without direct oversight from the county surrogate. A trust gives you more flexibility. As always, this video is for informational purposes only. This video is not legal advice, and I'm not recommending that any concept raised in this video is right for you. You are unique, and so is your situation, and you should consult an attorney regarding your situation. Now, I could spend well over an hour going through each component of this will and pointing out optional clauses and alternate language and going through various scenarios and situations. I'm not going to do that. If you're interested in learning more about a particular section of this document, message me. The purpose of this video is to provide a cursory overview of a sample pour-over will and to point out a few key components, the components that you must have to create a valid pour-over will in New Jersey. Let's go. Key component number one, identification of the testator. Here, Richard P. Smith is the testator. He's a fictional person in this example. Here we've included the testator's full legal name and a former name that he used. You should include all aliases and maiden names, and the name should be spelled as it appears on government documents like a driver's license. Also, good practice to provide the town and state to help identify the testator and the location where probate will occur. Next, key component number two, we have identification of family members. Always good practice to identify persons that may be interested in the estate. Here we're noting that the testator is divorced, that his ex is expressly omitted as a beneficiary, and that he has 4 adult children. If he had minor children, you would want to be naming a legal guardian for them elsewhere in the document. But here we have 4 adult children. Key component number 3, you must name an executor. Here the testator is naming his daughter as executor of the estate. She is charged with marshaling the assets, paying the estate expenses, paying any taxes that are owed, resolving issues with creditors, basically stepping into the shoes of the testator to do anything that he could have done had he been alive. In this case, her final act will be to distribute the remaining estate assets to the trustee of the revocable trust. Also note in the document that the executor here is waiving bond or any other security that the executor must post. Bond waiver is not essential, but it's generally favored. All right, here we have a non-residuary gift article. It's not a key component of this type of plan. Here we have an example of a testator that wants to leave certain items of tangible personal property such as tools, jewelry, artwork, family heirlooms, for example, to various family members, and he wants to do it without naming them all in the document. Also, since he may change his mind periodically, New Jersey law provides a way where he can make separate writings without the need for doing a new will. He could just take out a pad and paper and write, well, I leave my painting hanging in my living room of such and such a landscape to my daughter, to my son, whatever, sign it, and he'll date it he'll sign it and date it and store that writing along with his will. And he can do that periodically without the need of redoing his will. And further down, here's just an example of someone doing it both. Here he's leaving certain specific items of tangible personal property to his children. And maybe what's noteworthy here is that tangible property, all the rest of this tangible property that's not otherwise disposed, is devised directly to his kids without entering the trust. It's a simpler approach, and there are many ways of doing it, but here the testator trusts that his kids will act reasonably in agreeing on how the property will be distributed. So here's key component number 4. It's the devise to the trust. Here we have the meat of the document, but it doesn't say much. It reads, I give the balance of my estate to the trustee of the Richard P. Smith Living Trust, that's the name of his trust, to be added to the trust fund held thereunder. That's it. We don't know who the ultimate beneficiaries are. We would need to read the trust agreement, and we may not have standing to compel the trust's disclosure. So that's what I mean when I say the trust is private. The will is devising his estate to the trustee for the trustee to manage the estate under the terms contained within the trust agreement. And we don't know what that is. The trust agreement might have the same beneficiaries as children. It might include other beneficiaries that we don't know about. We don't know anything about what is in that trust. And this is the only document that will be filed with the county surrogate. And clearly, this is the most important part of a pour-over will. This is the language that makes the will a pour-over will. In other words, the assets of the estate are pouring into or flowing into his living revocable trust. I'll point out the fiduciary powers article. It's not essential. It's good practice to expressly provide the executor with the authority needed to do the job. Now, the authority is generally provided by statute, and here we're referencing that part of New Jersey law where someone can go to, the executor can go to and point to additional statutory authority. But it's good practice to provide in the document at least a sentence or two giving the executor the power to manage real and personal property. This is a short form of that example. Depending on the situation, these powers provisions can run for pages. Again, here we have another good component. It's not a key component. It's good practice. The point of this language is to facilitate the administration of the estate and to reduce unnecessary asset transfers. And then we have a payment of taxes article. We have, it's provided that all death taxes are going to be paid in accordance with applicable law then in effect. So that might be a good idea. It might not be a good idea. So there are many ways to provide for the payment of estate and inheritance taxes, and this is something that a lot of thought should be given before you just come up with a the default as applicable law. Moving along, that's it. And we have a place for the testator to sign. Generally, wills must be signed by the testator in the presence of two witnesses, and those names will appear below, right here. And then lastly, we have the self-proving affidavit. Again, here is where the testator is going to sign. Again, it's going to be witnessed by two people, and this time it will be in the presence of a notary, and the notary will sign and acknowledge this part of the document. And that's the will. So store the will someplace safe, review it periodically along with the trust being referenced. I hope this helps, and feel free to message me with any questions or comments.